public, and can I remind you all that whilst we're in public session, the committee meeting will be recorded and broadcast throughout Parliament buildings and online. Today we have 4 members attending in person, myself, Emma Shear, and the Vice Chair Mike Nesbitt, Michelle McElveen and Constance Stalford. And we have 3 members attending online. We've got Mark Turkin, Joan O'Dowd and Paula Bradshaw. You've got a kick back here. That's all right now. Okay, so we don't have any apologies, so we're going to take agenda items 2 and 3 together at the request of the witnesses. So you'll find a contribution from the bar as in table papers, which should have members should have received via email, and we now have a briefing from Peter Coll QC and Maria McCloskey. So Peter and Maria, you're very welcome.
Thanks very much. Thank you.
And you can begin your briefing when you're comfortable.
Okay, well, I think the plan was for me to take off, if that's okay with the committee. So good afternoon to everybody. Hopefully you can hear me okay.
Yes, thank you.
Okay, that's good. I want to thank you first of all very much for the opportunity to present virtually, as it turns out, unfortunately, in the current circumstances, to the committee on your consideration of issues relating to Bill of Rights for Northern Ireland. Just to say something first of all about who I am and the organisation I represent today. So my name is Peter Coll. I'm Vice Chair of the Bar of Northern Ireland and Vice Chair of the Bar Council of Northern Ireland. Bar Council is an elected body of 20 barristers, and we act as a representative body for the Bar of Northern Ireland, which comprises of over 650 self-employed barristers. And our independent practicing barristers specialise in the provision of expert legal advice and advocacy, aiming to serve the public interest by upholding the rule of law and the administration of justice. Great background to myself: I was called the bar in 1996, and I was called to the senior bar and became a QC 6 years ago. In my own legal practice, I specialise in administrative and public law, and I have some experience in representing government bodies primarily, but also sometimes appearing against them in court relating to judicial reviews, inquests, and the occasional public inquiry as well. Hopefully members have had the opportunity to review the written submission that we have filed with you that's been referred to by the Chair a short time ago. And you'll be glad to hear I don't propose to read that out, take time doing that. But there are a few points I'd like to highlight by way of opening remarks, and then I think Maria is going to speak then after that. And I think we're obviously happy to answer any questions or queries that you might have from us. So I'm conscious that the particular issue that I've been asked to address is about justiciability and enforcement issues relating to the Bill of Rights. And I appreciate that you've heard from some others previously in respect to that, and many people much more expert in that field than me. So I hope you'll bear with me in respect of what I have to say at this point. It's the view of the bar that in the context of the work you're currently undertaking, the committee must develop a clear and coherent approach towards what it ultimately aims to achieve through a Bill of Rights before it can really reach any conclusions on the justiciability of the socio-economic rights or potential models of enforcement. The issues surrounding the incorporation of these rights into legal systems have been the subject of extensive research and commentary in jurisdictions across the world with various different models, offering helpful comparators for your consideration. And I know you've taken some evidence already in respect of that. However, we consider as an organisation that it's essential that the committee settles upon the approach that works in the context of this specific jurisdiction in Northern Ireland. And discussions, as everybody in the committee will be well aware, on the Bill of Rights for Northern Ireland have been ongoing for over 20 years. And while the bar as an organisation doesn't at the moment express a particular opinion on how the the work of the committee should proceed in that regard. We very much hope to be able to contribute to an open and frank discussion on the practicalities that will surround the development of any Bill of Rights in due course, and that as that process continues and as the proposals, if they are to come, crystallise, we would hope to be able to fulfil a further consultative role in being able to assist the finalisation of that towards legislative effect. Secondly, it's also worth commenting on the role of the courts in considering the merits of developing a new Bill of Rights. And whilst it might legitimately be argued that accountability is the cornerstone of human rights, ensuring that those noble ideals transfer themselves from pieces of paper and worthy principles into actual practical application. And we ask you to remember, to acknowledge the courts as accountability mechanisms, is really the accountability mechanism of last resort in holding other branches of the state to account, the executive branch and indeed on occasion the legislative branch. And the creation of socio-economic rights through a Bill of Rights will not in itself necessarily result in these rights becoming easily justiciable. And it will be the underpinning of those headline rights that will perhaps be crucial. Watched the Lord Chief Justice giving evidence to you previously, and he talked about the granular detail, and that resonated with me. I think that the devil of all of this will be in the detail of how the Bill of Rights comes together and what the actual bite of those rights will be. So the role of the courts as a potential enforcement mechanism through the rights being justiciable cannot, I think, be entirely divorced from the political obligations which primarily must arise in respect of rights of that nature becoming legally consequential and justiciable. This is obviously not going to be, as you will have probably gathered already, a straightforward task. And there is ample evidence to show that the ability to realise the ambition and scope of public policy is subject to constraints, primarily, for example, of public expenditure and the dynamic associated with the system of government that exists in this jurisdiction. So there is a range of case law and that highlights that it's not the function of the courts to take decisions on questions relating to the executive branch's budgetary arrangements and the competing public priorities for the management of expenditure of public funds. And these will often obviously involve complex decisions taken in the context very often, unfortunately, of challenging economic backdrops. And in primary position, we would say that the immediate accountability mechanism in respect of that is that exercised by you as legislators and decision makers in the Assembly in holding the executive to account in political terms for the budgetary expenditure of public funds. And by way of example of that, we've referred in our written piece to a 2017 Court of Appeal case here of the Department of Justice and Bail and the Police Ombudsman from Northern Ireland. And in that case, the judgment was delivered by Lord Justice Gillen, and he highlighted a number of important principles in distinguishing between decisions of the executive and the role of the court, which perhaps bear briefly repeating here, in which he said, normally, the question of whether the government allocates sufficient resources to any particular area of state activity is not justiciable. There should be little scope or necessity for the court to engage in microscopic examination of the respective merits of competing macroeconomic evaluations of a decision involving the allocation of diminishing resources. These are matters for policymakers rather than judges, for the executive rather than for the judiciary. I understand that Sir John Gillen may be giving evidence to the committee in the coming weeks, and no doubt that that's territory you may wish to explore further with him. But for what it's worth, from my perspective, seeing that court will in the court setting in terms of enforceability, much will always depend on the wording. Again, back to this point of the granular detail of the statutory right. And the tighter that it is, the more likely the court will approach it as a hard-edged matter of pure legal entitlement, as opposed to a matter of discretionary executive branch decision-making, which the court is perhaps not well equipped to deal with. So the justiciability issue is one that traditionally the courts have been perhaps wary of interfering in the political field. And but at the same time, it's not to be said that justiciability or legal enforcement in the courts of legislative rights will be determined in the negative because the matter gives rise to political interest or indeed political controversy on occasion. And one might say that in the public law and administrative law setting in particular, the courts on a day-by-day basis make decisions on matters which are of great political interest and indeed on occasion concern matters of great political controversy. And the committee will probably be aware that there's an ongoing review at the moment by Westminster into administrative law, the independent review of administrative law, and really a review about the scope and extent of judicial review powers, primarily in England and Wales, but potentially with impacts more widely. And in the bar's submission recently to that review, we made reference to the Supreme Court case last year, the parliamentary prorogation case, Cherry and Miller number 2, and we noted what was said by the Supreme Court in respect of that decision and the context in which it had to look into the political matters, and said courts cannot decide political questions. The fact that a legal dispute concerns the conduct of politicians or arises from a matter of political controversy has never been sufficient reason for courts to refuse to consider it. Almost all important decisions made by the executive have a political hue to them. Nevertheless, the courts have exercised a supervisory jurisdiction over the decisions of the executive for centuries, and many, if not most, of the constitutional cases in our legal history have been concerned with politics in that case. So I think really what we as a bar say in respect to this issue is the courts are competent to answer questions where the legal effect of political decisions is proper and statutory provisions will not be immune from the court's review simply on the basis that it strays potentially into political territory. But there is a balance and a line to be struck. And for example, even very hot off the press in yesterday's leave application in the High Court in Belfast in relation to a challenge to the Prime Minister's signing of the Brexit withdrawal agreement as reported in the papers today, in which Mr Justice McLinden found that the court really has no constitutional role or function in delving into the mindset of the Prime Minister at the time he signed the withdrawal agreement. And the argument in that case has been that alleged there was an allegation that the Prime Minister never had planned to stick to the terms of the EU Withdrawal Agreement Act passed by Parliament, and that he was planning to take a different course. And the counter-argument put forward on behalf of the government was issues of that nature relating to foreign policy and the Prime Minister's actions in signing the agreement shouldn't be subject to judicial scrutiny, that he was exercising the will of Parliament and that was a sovereign act, and that it's not for the court to seek to engage in some kind of almost psychological inquiry into what was in the state of the Prime Minister's mind at the time, and that's effectively the view the court took of it yesterday in that regard, and leave was refused. So I suppose in summary on this point, really what I'm trying to get across is that if the committee ultimately decides, and if the outcome is that there is merit in developing a new Bill of Rights, that process must take account of the need to be very careful in drafting the scope of the legislation that might give effect to any social economic rights, because those rights engage complex areas of policy relevant to not just the freedom of both the legislative capacity within the Assembly itself, but also in the executive branch, the ministerial decision making in terms of the expenditure of public funds primarily. And that necessitates, I think, on your part, a thorough explanation of the potential consequences of enforcement by the courts, particularly when you're considering any financial repercussions it could have for other branches of government, and indeed potentially outside of the devolved function, even in Northern Ireland, into the central UK function that still remains within Northern Ireland. I think it might also be said that a well-crafted and tightly drawn Bill of Rights would reduce the likelihood of any dispute as to what that document provides for, and for the need for judicial interpretation and determination of any dispute. But it would be unrealistic, I think, to assume that the limits of any new rights and how they should be applied in any individual set of circumstances would not be tested in our courts on a regular basis. And that's currently the very clear experience of practitioners, and indeed I would say many government departments and public agencies more generally, in the context of the current model that we have of human rights law in this jurisdiction through the Human Rights Act. So the committee, I think, should be very realistic in anticipating that there is should be every expectation that that will also become the norm for judicial consideration of any newly created rights. And particularly one might say if the legislation were to be drawn in a very determinative fashion with hard-edged rights rather than vague rights or aspirational rights, target duty rights, and that the tighter and more determinative the approach that's adopted, the greater you can expect enforcement to follow in a practical level through the courts, and the greater impact, therefore, that will have on freedom to create policy and indeed freedom in expenditure of public funds. So one must be careful, I think, of that legislative straitjacket that could potentially come from this. And it certainly, in that sense, would give rise to fertile territory for the lawyers and the ingenuity of the legal mind to push the boundaries of what those rights should mean in practical application. So I suppose really in that sense what I'd say in summary is that you, and I say you, I mean generally speaking, those who might be involved in being able to bring about a Bill of Rights, if that's the decision, that you should follow the old maxim of being careful what you wish for, because you might get it. And so on that pithy note, that's my brief summary of our written briefing that we have provided to you. And obviously I'd be delighted after Maria's contribution to answer any follow-up questions or any queries that you have for me.
Thank you very much, Peter. Maria, do you want to?
Yes. Can you hear me okay?
We can.
Okay, great. So thank you very much, Peter, and thank you, Chair, and to the committee for inviting the Law Society of Northern Ireland to present before you today and give evidence. As a bit of background to me, my name is Maria McCloskey and I am an immigration solicitor at the Children's Law Centre. I'm also chair of the Law Society of Northern Ireland's Human Rights and Equality Group, and that group sits more as an informal group within the rather than being a formal committee of the Law Society, and it's discussions within that group that have led to the basis of this presentation today rather than a wider consultation with the entire membership of the Law Society of Northern Ireland. But thank you nonetheless, and I think it's a nice coincidence that today is, of course, International Human Rights Day, and I'm very much coming from a human rights perspective. So there are three main points that I wish to highlight in my presentation. The first is that a rights-based approach was part of the DNA of the Belfast Good Friday Agreement. The second is that the loss of the Charter of Fundamental Rights and the gaps that it is likely to leave, we think can potentially be addressed through a Bill of Rights for Northern Ireland. And the third is the importance of the enforceability of rights. So to give some context to our position, I think that there has been a very clear and worrying disintegration of human rights protections in the UK over recent months and years. And despite assurances that human rights would be on an equal footing following the UK's exit from the European Union, there are strong reasons to suggest that this might not be so. On Monday of this week, the government announced a review of the Human Rights Act. This has been framed in the past as wanting to consider the relationship between the European Court of Human Rights and domestic courts. And it will certainly be sold as an appropriate time to review the Human Rights Act. But essentially, from our perspective, the government doesn't like when it loses challenges, and particularly when those challenges are based on Article 8 rights to private and family life. At such times, the government, when it has lost a challenge, can frame human rights such that they are a threat to society rather than existing to protect members of that society. And very often there can be a complete disregard for the context and the circumstances of certain legal challenges, so that the nuances and difficulties of balancing competing rights can get completely ignored. Another threat might be seen by the commencement earlier this year of the independent review of the administrative law, and that is the judicial review mechanism. So the Law Society has responded to that consultation and outlined our concerns that the agenda of the government is to limit the powers of the court to review administrative decisions in order to shield the government and those decisions from scrutiny. So judicial reviews should be seen as a way in which to rectify unforeseen breaches of the law, precisely because elected branches of government can't foresee every application of a policy. Not only does a judicial review mechanism resolve unforeseen breaches, but it increases the legitimacy of the government by providing independent oversight. So on to the first of my main points, and that is that a rights-based approach was the core tenet of the Belfast Good Friday Agreement. The peace agreement obviously grew out of conflict here, and that is a history which has shaped us and will continue to shape us going forward. Understandably, at the time, there was a lot of emphasis when discussing the Bill of Rights within the text of the agreement about the both communities aspect. But the main text of the agreement, in terms of discussing safeguards, was specifically about the protection of equality for all sections of the community. And the landscape of Northern Ireland has changed significantly in the last 22 years. And I think it's vital that all sections of the community are represented and considered in this discussion. The thing about a Bill of Rights is that it confers benefits on everyone. It doesn't take something away from one group and give it to another. And I would urge you to hold that rights-based framework within your sights as you continue your work on this committee. And that brings me on to the second main point, which is the loss of the Charter of Fundamental Rights and Freedoms. So the justification for not including the Charter in domestic law following the UK's exit from the European Union was that the rights of the Charter the rights that the Charter confers won't be weakened. And this was supported by the argument that many of the rights of the Charter are directly replicated in the European Convention of Human Rights, which is incorporated into domestic law, of course, through the Human Rights Act. As already outlined, we think there is now a threat to the Human Rights Act in and of itself. But a couple of other key points about the Charter. And first of all, the Charter provides fundamental rights. It is a basis upon which a direct challenge can be brought to domestic law. And that ability to strike down domestic legislation doesn't exist within the European Convention of Human Rights. Secondly, the Charter functioned in such a way that it could create new rights and allow for developments and changes within society. For example, the right to be forgotten was based upon relying on Charter rights. And thirdly, on the Charter is that despite the assertions of the government, the rights that it confers won't be directly replicated in their entirety in domestic law. So, for example, on children's rights, something that the Children's Law Centre has been to the forefront of campaigning and advocating on, the best interests principle is no longer available as it was through the Charter, because the Court of Justice of the European Union had the ability to read in the United Nations the Convention on the Rights of the Child. And that, of course, is an international treaty which has been ratified by the UK, but it hasn't been incorporated into domestic law. So the loss of the Charter of Fundamental Rights, we believe, needs to be counterbalanced by strengthening the statutory enforcement of human rights in Northern Ireland. And I think now more than ever, the impetus for a Bill of Rights should be obvious. And I think this should be seen as a golden opportunity to guard against further weakening of rights. And thirdly, on the point about enforceability, unenforceable rights aren't really rights at all. So it is, of course, for the Assembly to determine the nature, scope and the operation of the bill, but a few points that I wish to make. The less ambiguous the bill is, the less likely it is that individuals will need to seek legal intervention. It will require that granularity that Peter and the Lord Chief Justice has spoken of, and the legislative framework to support whatever is in the bill. And a number of models have already been considered and presented to you in detail by other experts, particularly by the Human Rights Centre at Queen's. It should be remembered that courts are a measure of last resort. So the first port of call is on the implementation and then the adherence to any Bill of Rights. And I think the pre-legislative scrutiny and the role of a standing committee at Stormont would be key components of this. The greater the level of commitment and compliance by the government, the less need there will be for individuals to come to lawyers and seek assistance by way of legal intervention. Neither courts nor legal professionals invent or create obligations. They are the means by which individuals can seek to review the decisions made by government. And there are many examples of how this can work based on models around the world. There are also some inventive and novel suggestions, such as by Professor Kate O'Regan, in relation to localised accessible tribunals. And that's not only a tangible and accessible method for individuals to access their rights, but it would also act as a filtering mechanism for potential legal challenges. When it does get to the stage of legal proceedings, as undoubtedly it would, there's already a natural filtering mechanism at the leave stage of judicial reviews. There are, of course, barriers to legal challenges posed by funding constraints and lack of legal literacy. And I think access to justice, which is a wider issue, should remain a key consideration in the outworkings of the Bill of Rights. Accessibility and clarity are key ingredients, both for legal professionals and for the public. And this would require a commitment to embedding the the Bill of Rights in this jurisdiction by providing training and working with the various legal professionals. I believe that human rights shouldn't be an abstract concept, but it should be accessible and tangible. Whatever the bill contains, we as legal professionals will fulfil our duty by advising clients as to whether they might use it in order to resolve their particular issue or complaint. On that point, I wish to touch upon threats not only to human rights, but to the wider rule of law principle. And I'm referring to the ongoing attacks on the legal profession, and in particular, comments by the Home Secretary and the Prime Minister, which completely undermine the role of solicitors and barristers, and thereby the rule of law itself. As a result, there are real fears about safety. And bearing in mind the particular circumstances of Northern Ireland, and the catastrophic toll borne by the legal profession in the past, I think that this issue warrants some serious reflection in and of itself. In 1990, the UN Commissioner for Human Rights set out a number of basic principles on the role of human rights lawyers. It referred specifically to criminal proceedings, but I think that the principles apply across the board for human rights lawyers. And within it is the principle that lawyers shall at all times maintain the honour and dignity of their profession as essential agents of the administration of justice. So for human rights to be meaningful, they must be enforceable, and that requires lawyers willing to take on unpopular causes without facing attacks by government ministers. In conclusion, protecting human rights shouldn't depend on the whim of the government. The short-term nature of elected politicians must give way to long-term commitments to a human rights framework for Northern Ireland. The hostile environment and the threats to human rights are undermining those protections, which, taken in the round, should be deeply concerning to all. The Bill of Rights presents an opportunity to redress the imbalance and to protect the citizens here in the future. And I just want to finish by quoting the late Sir Brian Kerr, whose passing the Law Society mourns, and I wish to take this opportunity to extend our sympathies to his family and friends. In a relatively recent interview, Lord Kerr said, "Lawyers are not activists, they are reactivists. People bring problems to lawyers, and lawyers decide whether they can be fitted into some sort of legal framework in which a legitimate challenge can be taken. I can understand the government is less than pleased when challenges are made to decisions that they have taken frequently after very considerable deliberations. But it doesn't seem to me that attacking lawyers who provide the services that allow those challenges to be made is particularly profitable. Ministers might be irated by legal challenges which may appear to them to be frivolous or misconceived. But if we are operating a healthy democracy, what the judiciary provides is a vouching or checking mechanism for the validity of laws that Parliament has passed or appropriate international treaties to which we have subscribed. So thank you very much for the opportunity to present. The Law Society would of course be happy to continue working on this in the future, and I'm happy now to take any questions along with Peter. Thank you.
Thank you very much to you both, two interesting presentations. If you don't mind, I'll maybe divide my questions, and Peter, I'll direct my first question to yourself and then move on to Maria. I noticed both in your oral presentation and in the submission that you gave us, you make reference to sort of the different remedies and I know that there's a focus on accountability in terms of a Bill of Rights, and the specific reference you made to the sort of pre-legislative scrutiny model. And I got from the presentation that you would see sort of a JR as a last resort. I wondered if you would expand on that.
In the final analysis, when you have either administrative executive decision making, or to the extent where it might be subject to challenge legislative decision making, particularly by a body such as the Assembly, which it doesn't carry the sovereignty of Parliament type tag that Westminster might have. But even with that, Westminster under the Human Rights Act can find its laws coming under direct attack. The point, I suppose, really is that if you when the decision-making, the law itself is given practical application, it's its impact in the life of the individual that's affected that brings the question of law to the fore. Maria touched on this a little bit. She said that about the accessibility to the law. And there's little point in having all the panoply of rights if, in fact, the practical means by which a member of society can actually have those rights protected and enforced is not open to them. So judicial review, in that sense, provides one of the main protections for the individual, for the citizen, against the state and unlawful actions or decision making by the state. But it's perhaps not the only means by which that can be done. So there are other models that are perhaps slightly less legalistic that could also be incorporated into it, such as the idea of clear scrutiny in advance. I know that the way the Assembly works at the moment, for example, that laws being passed by the Assembly do go through a process of scrutiny under the committee system, which you'll all be very familiar with, more so than I am. But even with that in place, there is always the opportunity for error. There's always the opportunity for interpretation. And I think when it comes down to it, if you move into territory of creating rights, that you have to expect that they will give rise to legal action by way of enforcement of them. The clearer and the more determinative those rights are, in one sense, the better, because they leave perhaps less room for ambiguity or interpretation. But as against that, the more determinative you make those rights, then the more hard-edged they are in that sense, the easier they are for the courts to grapple with and to enforce. So you move away effectively from the aspirational right or the target right, and away from that sort of political or public policy form, more squarely into the legal enforceability world of what does the law say, and remembering that really when it boils down to it, that's what the lawyers and the judges were there to do. They're there to see the upholding of the rule of law. The legislative branch makes the laws, and the judicial branch and the lawyers take to do with the enforcement and interpretation of them. So it is a pro last resort, but I don't think you should take from that I mean that it's going to be the occasional or rare beast. I don't think it will be. I mean, and as I said in the presentation, the Human Rights Act has marked itself over the last 20 years or so of its operation by being present in so many fields that initially set up in 1998 and coming effective in 2000 might never have been thought possible that would even be brought into court. So these things are a way of expanding and growing. And I think the Chief Justice touched on this in his presentation to you a while ago when he said it's very difficult to predict just exactly what the implications of creating these kinds of rights will be and putting them into the legal sphere in that sense.
Thanks, Peter.
Not sure that answers the question, but
No, I suppose further to that, because you do use the example of the South African model, and we've had presentations obviously from people that were involved in that process and former judges in South Africa who talk about the progressive realisation model, and I suppose in my mind it could somewhat be used as almost like it's that measure of accountability for governments or ministers or executives, that if there's a clear bill of rights there, that a government then knows what its responsibilities are and have to have a mind to that when legislating.
Yeah, well, I think that's undoubtedly right. I mean, if you have, just as for example at the moment under the Human Rights Act, you have a series of mostly civil and political orientated rights that are enshrined in domestic law and have a very high standing within that domestic law setting, so that if in the passing of laws or in the taking of executive decisions there's conflict with what those rights provide for, then a government agency entering into that does so at risk, because those rights are hard-edged and enforceable. And it's the meat and drink of our courts nowadays to take to do with that kind of territory. So I think it really touches back in, Chair, with the point I've made that if you create rights that are hard-edged and determinative, you can't expect them to be enforced in a proactive fashion, because that's what the law would require. If the rights are more generic, target rights, then it becomes more difficult for the courts to grapple with them, be more into the issue about whether they really are justiciable or whether it involves the courts traipsing into the political territory and the public policy territory. And some of the other models, it seems to me, I'm no expert on them, I have to say, in terms of the South African approach, etc. And you have heard from experts on this, but it seems to me that they suggest at times of something that is more enforceability in political terms or in policy terms rather than in pure legal terms. So in other words, they almost become, maybe it's not a great way of putting it, but almost like an enhanced programme for government or something like that, that it becomes the standard bearer against which government policy is gauged and judged, but that the enforceability of that might not be necessarily hard-edged in court. It might be something that's dealt with within the Assembly itself in a committee-type structure or, of course, in the final analysis, it might be accountability from the people at elections.
Thank you very much, Peter. Maria, I want to ask you a question. We've had a number of these presentations, obviously, at this point, and I've asked a lot of the presenters about the gaps that we were going to have as a result of Brexit, and whether or not there was scope within the creation of a Bill of Rights to plug some of those gaps. Now, you said quite explicitly that you believe that we were going to have gaps as a result of the loss of the Charter of Fundamental Rights, and that a Bill of Rights could have plugged some of those gaps. I just wonder, we're 21 days away now. Is that reasonable that we have time now to do that when we leave the EU, that we can hold on to some of those rights via a Bill of Rights?
Well, my view on that is that when we do exit from the European Union, obviously there's going to be an element of delay, and how this impacts upon rights going forward is going to take some time to become clear on. I think that obviously the work of your committee, and I know that you're not due to submit your final report until February of 2022, but I do see that as an opportunity to look at what are we losing from the Charter of Fundamental Rights, what are we losing from the statutory framework here at the moment, and what can we then build in. And the things that I was focusing on in relation to children's rights, in relation to the standalone clause on equality, and the fact that we haven't implemented the race equality strategy here. I think that certainly those are the things, the key things that we need to be looking at in terms of plugging those gaps. So yes, I think it's difficult in terms of timing, but I think that should drive the committee on in terms of thinking, what are we losing, and what then can we bring in through the Bill of Rights?
Yeah, so almost what you're saying is that it nearly increases the motivation, and
I think so. I think that it should increase the motivation.
The second thing that I wanted to ask you about, and it's perhaps slightly removed from your presentation, but just in terms and following on from Brexit, we can see the British government's EU settlement scheme, and the challenges that is presenting, and already concerns have been raised from different human rights organisations and from people within the law about the time frame and the accessibility of that, and particularly for frontier workers and for migrant workers that are here. And we don't know yet really. I think that there has been a clause within it that you can't apply if you're someone who's an Irish citizen in the north who has never expressed British identity, but people have applied and have been granted it. And I just wondered if you had thoughts on that, or the implications that has for people's rights as we move out of the EU.
Well, I haven't been working specifically on the EU settlement scheme, but I do know from colleagues that obviously the ability to apply through that scheme is time limited. And I mean, it's time limited. We are coming up on that time limit. At the end of June next year, you will not be able to apply for the EU settlement scheme as it stands at the moment. And obviously, as the Emma D'Souza case the challenge was withdrawn on the basis that that she could remedy her issue because of the EU settlement scheme being open. That's going to close, and so the potential for legal challenges beyond that still exists. But from the perspective of the children's rights, for example, that I do know about, we are working, and my colleague is working a significant amount of work going into trying to apply for the EU settlement scheme on behalf of looked after children, a vulnerable group of people who have largely been forgotten or who haven't been to the forefront of this issue. And for those vulnerable individuals and children who don't have documentation, the ability to apply through the scheme is much, much more difficult. And requires paper application and different types of evidence. So it's not as smooth as you might think from if you had, if you applied through the app, it's fairly straightforward if you have some sort of document, but if you don't, it's not straightforward. And the other major concern is that a large number of people who can apply through the scheme won't know about this until after the time has passed. So I know that I've gone off point and you're talking about Irish citizens, but I do think that there are certainly concerns about that going forward.
Thank you, and I suppose I'll finish with that. That's, I suppose, why I'm asking questions like that is we obviously as a committee are here to consider creating a Bill of Rights as per 1998, considering the particular circumstances of the North and the impact of Brexit. And as you pointed out at the beginning of your presentation, I suppose the demographics of the North and the situation here is a lot different now to what it was in 1998. Brexit is obviously going to have massive implications, and we have an increasing migrant worker population here, and people from those communities are incredibly worried. And I think when we're talking about rights, it's important to consider the loss of rights to populations that are maybe usually ignored or forgotten about, and if there's any potential for us to expand upon the rights that those people have access to, it's incumbent on us to do so. So thank you both very much. I'm going to pass now to the Vice Chair, Mike.
Chair, thank you, and Maria and Peter, thanks for engaging with us. Peter, first of all, I take your point that the more tightly and clearly we use our language in a Bill of Rights, the less room for ambiguity and potentially successful legal challenge. But when it comes to economic and social rights, it seems to me there would be an inevitability that there'll be a form of aspirational writing within there. So my question is, how comfortable and well equipped do you think your members would be to argue concepts like progressive realisation and the use of maximum available resources?
I would suspect that many of my colleagues would feel very happy to have the opportunity to make arguments along those lines, Mike. And I think, as I indicated, the ingenuity of the legal mind is such that if provided with tools that allow the opportunity to achieve a result for one's clients, there won't be any great reluctance whatsoever on the part of the lawyers in this jurisdiction to use what's available to them to achieve those aims. So if you have creation of legal rights, even if they are of that more aspirational nature rather than hard-edged specific rights, such as a right to a particular type of benefit in particular circumstances, something of that nature, which is usually reasonably straightforward. You look to what the law says, you look to the individual circumstances, you apply them together and you get a result. If you have a more aspirational aspect to it, then I think really the two interrelated points I would make to you is that yes, you can certainly expect a lot of litigation in relation to them, but alongside that, there will be a cultural battle, maybe, in the sense of the generalised historic reluctance of the courts and the law generally to engage with rights that sit in matters that sit in the political sphere rather than the legal sphere. I think that's really the key point that we're trying to get across about justiciability, which is what really you've asked us to think about today, is that if you're going to create rights, if they're not hard-edged, then how do they fit into accountability and enforcement mechanisms? That will not necessarily be straightforward in the legal sense and may also require some of these other accountability or enforcement mechanisms that you're receiving evidence and advice about. But from the legal perspective, I suppose really what I can bring to this is from the legal perspective, there certainly would be an opportunity to develop those aspirational rights, but that would not necessarily be something that would overnight lead to hard-edged outcomes. And that's been the experience, perhaps to an extent, in some of the aspects of the European Convention, which touch upon Article 14 of the Convention about the discrimination aspects. So we have a hard-edged right under the Convention may not apply specifically to that individual's circumstances, but that they can compare themselves to somebody else who does benefit from that right in a different way. And that's fertile territory for dispute and difficulty. And it currently provides a lot of difficulty in legal interpretation. So I could see a risk of that kind of situation developing if you have more aspirational rights.
Thanks, Peter. You're crystal clear, and many others are, that it's not for the courts to get involved in the allocation of budgets by an executive. But is there not a tension between that statement and perhaps having to argue that a specific minister or department has not used maximum available resource?
Well, it depends again, I suppose, on what the right says and the depth or the granular detail of it. Again, to use that phrase, at the moment, you would expect the courts to say if there's a choice between expenditure in one field and expenditure in another, and the courts might say, well, that's not really territory that a judge can engage with. It's not. The judge is not elected by the people to distribute public funds. That's primarily a political matter for ministers. And so I think it depends. The ministerial decision-making in respect of that, if that's what we're talking about, may be constrained in circumstances depending on the statutory backdrop. So if the statute provides a clear steer as to what must be provided for the individual. And if in the circumstances the minister or the department concerned have money available, it might be more difficult for them to argue, well, we're not in the territory of difficult decisions of divvying up public money that the court should leave for executive decision making.
Thanks, Peter. I have a question for you both. So perhaps Peter first before I go over to Maria. With regard to JRs, it's been put to us that one possibility in terms of a Bill of Rights is that you would build in a sunrise clause whereby you could not take a JR for a period of, for example, 5 years. What's your view on that, Peter?
It's quite ingenious in one respect, I suppose it depends, again, in itself how it is done. Would it by itself be subject to some kind of potential ground of challenge? Back to the ingenuity of the legal mind again, and we wouldn't rule that out. But again, I think it really comes down to, for example, if this, if it ends up that the Bill of Rights is made through a Westminster enactment rather than an Assembly enactment, it might hard edge that a little bit more, and it might be said, well, that's the clear will of Parliament and that's the way it is. And it might allow an opportunity for a lot of this to bed down. I think perhaps, Mike, the major problem I could see with that is it may not necessarily even be really a legal issue, it's more just a matter of practicality. Until such time as the decision makers would be faced with circumstances where their decision making relating to those rights could be subject to enforcement, but the pressure may not be on to actually engage with it. So you might have that opportunity for slow burn and for people to get their head around the idea, but as opposed to a sort of a year zero type approach and a sudden running start. But I can see all kinds of practical problems arising from it, and you couldn't rule out, I think, the possibility of some legal issues, and whether it might be seen to even in itself bring into play elements of convention rights. So, one of the interesting aspects of all of this that you'll have to consider is how will the Bill of Rights fit in and sit alongside the rights that currently exist under European Convention, and whether is it possible that the European Convention might in itself impact into and drive what is meant by the new rights that are created. It's fascinating stuff, actually, and very interesting. What might come from all of this.
Okay, Peter, thanks. That's very interesting. Thank you. Maria, what about you? Because you spoke positively about JRs.
Yes, I did. I mean, I think the suggestion of a sunrise clause, and it's going to sound like I'm just echoing the comments of a QC, but I think it's pretty ingenious idea. I know that it has worked in other, or it is working in other scenarios around the world, and I noticed also that the Lord Chief Justice talked about, avoiding the Big Bang, but as against that, there are potentially some difficulties. I mean, I think that it makes sense in circumstances where the government might be concerned about challenges being brought, that there might be some element of delay to allow it to embed and to allow for certain departments to get their house in order, I suppose, to ensure that they are compliant with the Bill of Rights. So personally, I think that it would probably make sense in this context where there is that concern, but that's not to take away from the potential issues or difficulties that would present.
Mike, I wonder if I might just, Maria's made a very good point there that I would like to just add something to, if that's acceptable to the committee, very, very briefly. And it's just to draw an example, for example, with the Human Rights Act itself. So the Human Rights Act was passed in 1998, but it didn't come into effect until the 1st of October 2000. So, and that's not uncommon, of course, for statutes to be created but not to be commenced until some time thereafter. So, without the drama that comes from the idea of a sunrise clause, there would certainly be opportunity to create the bill one day, but not to expect that it would come into operation the next day, and to allow everybody, not just the government departments, but everybody in Northern Ireland the opportunity to work out, well, what's this going to mean for us and how can we use it? So I think that would be, Maria's quite right, but I think that would be almost essential, and I'm sure that's something that you all would easily recognise.
Okay, so that's a sort of form of post-legislative scrutiny. But Maria, yeah, Maria, you're keen on pre-legislative scrutiny. I wonder if you could just expand on that. And how you see it working, not just in terms of perhaps a specific new Stormont committee, but engagements with bodies like the Children's Law Centre.
So I think that in terms of pre-legislative scrutiny, I'm talking about maybe rolling that in with a standing committee who, when reviewing new pieces of legislation, will consider and consult with the likes of the Children's Law Centre as to the level of compliance with the Bill of Rights, so that if there are issues within the legislation that require to be amended to complement the Bill of Rights, then it can be done at a pre-legislative stage, and that before then the legislation passes and you find, well, there's a problem and then there's a challenge, that you will have avoided that from the outset. So that's really what I was talking about in that regard.
And I think you would be one, I think Dominic Grieve was another, who said, really we don't know what the full impact on rights will be post the transition period. So how do you counter an argument that we should wait and see rather than continue with this work of this committee?
Well, from a personal perspective, there has been some waiting and seeing about certain things, only to be disappointed and thinking, when you take these things on an individual basis and people can consider them in silos, I suppose you think, well, that's not huge impact. But from my perspective, certainly it feels like a chipping away and a continual chipping away at rights, which when we get 10 years down the line, I would be concerned if that trend continues. And I think that at that stage then it could potentially be too late, because opportunities like this may not be around. And I think that the time to act is always now.
And I suppose the other thing is, if there was a Bill of Rights, that's not the end of the journey, because rights evolve over time.
Absolutely. And I think that that's exactly where, the role of lawyers and the courts come in, because you can't foresee every impact. But what I would say on that is that Bills of Rights exist around the world. They exist in post-conflict societies. They, work to a greater or less extent, but there are certainly plenty of models from which the most positive aspects can be taken for the purposes of informing your work.
Okay. Maria and Peter, thank you both very much. Thank you, Chair.
Thank you.
Michelle?
Okay, thank you, and thank you very much, both of you, for your presentations. And I suppose my questions have primarily been already addressed through the presentation and also through the briefing that was provided by the bar in advance. I just really want to pick up on one point that was raised within Peter's paper, which was in relation to a preamble. And obviously you said in your presentation the devil was in the detail, and yet we're supposed really, when we're looking at what you've referred to in your paper, you're talking about a scope for a general preamble. Could you maybe expand on what you would anticipate perhaps being in, or suggest what should be in a preamble?
Okay, well, I don't think I could. I mean, I certainly can work on what the concepts might be, but the content of the preamble, I think, is something that will fall to politicians to decide primarily. I think the idea behind it is that even if you have within the body of the Bill of Rights hard-edged rights, that you might still want to set the tone for what you see them as meaning in practical terms on the ground in a preamble. And even more so if in fact the Bill of Rights doesn't include hard-edged, granular, detailed rights, and if they're more of the aspirational nature. So the preamble might set out something along the lines of, why are we here? Why do we have the Bill of Rights? What's the purpose in having the Bill of Rights? What does it sought to achieve by the Bill of Rights? And it might also provide some steer to the courts as to how it might go about interpreting those rights and what it might do in making them effective or not do in making them effective. So the preamble would provide an opportunity to set the parameters within which the rights created within the document itself will have actual effect. And I think that's really, I suppose, where we might see the role of a preamble coming in. But obviously there are dangers in that as well. I mean, if you look at it in the normal sense, when you're in your day-to-day business of creating laws, the statutes that you create, the statutory instruments you create, they don't generally have preambles. They pretty much get to it. It might be a very brief setting of context, but really not. And maybe an explanatory note that might cover some of that territory a little bit more. Ordinarily, the explanatory note will have a limited role in legal interpretation. So I think the preamble idea will allow you an opportunity to perhaps do something different in that regard and to set the tone and parameters of how the document itself might become a living document as opposed to something that gathers dust on lawyers' shelves.
Okay, thank you. And Maria, have you given any consideration to what a preamble may look like?
I mean, before Peter spoke, I was thinking it is about setting the tone and the context. And I think that, within that, sometimes the preamble can be more accessible maybe to individuals rather than the finer detail of the rights themselves. So, I mean, I don't really have anything further to add to that, sorry.
Okay, no, thank you.
No problem, Michelle. We're now going to move to the members that are with us via Starlight. So I can see that Paula has her hands up.
Yes, thank you very much. My question relates to today, as you outlined there, it's Human Rights Day, and the Human Rights Commission launched their annual statement, and unfortunately I was at the Health Committee, so I wasn't able to see it, but I had a quick look online there while you were speaking, and there's 46 actions, for want of a better word. Some of them are obviously responsibility of the Home Office, but it strikes me in those actions that a lot of them are like the Single Equality Act or a new disability forum. A lot of the stuff we could do to address deficiencies or perceived deficiencies in human rights here in Northern Ireland without a Bill of Rights per se. How would you respond to that?
Well, if you're asking me that, Paul, yes, I think you're right, absolutely. And very many pieces of what might be described in non-pejorative ways, ordinary pieces of legislation, do exactly what you've just described and provide rights for individuals which are not at all trivial and in fact are of great practical, meaningful importance day to day for thousands and thousands of people in this jurisdiction. So I think you're absolutely right to identify that it's not an either or situation. You know, either you have a Bill of Rights or all the rights that you might want to create will fall away. I think maybe the issue for you all to grapple with is, and in fact the chair dealt with this in passing a short time ago as well, but you're looking to what's required of a Bill of Rights potentially in the particular circumstances of Northern Ireland, and that operates in the context of what rights instruments already exist, primarily, for example, the Human Rights Act and the European Convention being incorporated through it. Maria's talked about the EU Charter, which obviously is going to be of more limited effect, potentially depending on what happens in any deal that may or may not be done into the future in the next few days. And so alongside that, you have a whole panoply of statutory rights and indeed common law rights, which are recognised by the courts outside of pure statutory form in this jurisdiction. And they all exist and they're all there. And you have an opportunity on an ongoing basis to add to those. And I know that indeed you do on a regular basis add to those. And you referred to the Single Equality Act idea that exists in England and Wales, whether that should be replicated here. But also, I mean, there's been some recent public discourse about on the anniversary of the Disability Discrimination Act, 1995, and the impact of it, which has been very far-reaching, but it's obviously showing its age a little bit and perhaps needs refreshed, perhaps. And so those are matters that are very important, I think, and shouldn't be lost sight of. And I know that you won't lose sight of the very fact, indeed, that you've raised it today.
Just following on from that, and thank you. You mentioned a number there, the Human Rights Act, for example, and last week when Professor Bryce Dixon was here, I'd asked him the question around would it be just useful really to codify into one sort of bill, one sort of act, a lot of those human rights, adding in obviously the particular circumstances and a few tidying up exercises, but not to make it too expansive, but to just give it one focal, all the human rights sort of into one focal bill. Would that be something that you think that we could deliver here and would actually achieve what the wider community would have in terms of expectation?
Well, I made the point a short time ago, and I think it maybe touches on what you've said, that one of the things you need to think carefully about is how any new rights that might be created in the Bill of Rights, how they will interact with and be influenced by and developed by the Human Rights Act and the European Convention. So, is it a possibility to effectively take the Human Rights Act and put it into a new statutory framework? Possibly, yes. There are all kinds of technical issues that might come from that. I mean, obviously, the Human Rights Act is an act of Westminster. I don't know if it, and I think it's probably still an open question as to whether a Bill of Rights here, if it were to be enacted, would be done through Stormont or through Westminster. The Human Rights Act carries with it a very powerful mechanism whereby acts of Westminster, which carries that tenor of parliamentary supremacy, that they can be declared incompatible with the European Convention with the Human Rights Act. And that has a political impact, primarily in that Parliament then has to address what it's going to do about that. It doesn't necessarily strike the Act down, obviously, in that sense, because parliamentary sovereignty is maintained. So I think there's all kinds of very technical interplays with that you need to be careful about how that's done. Bryce, I didn't get the opportunity to see what Bryce said, and Bryce would be very well placed, I think, to have spoken to you about those very important technical issues, and he may well have done that. So I'm not terribly excited of just how you might take those technical aspects through, other than to say there are obviously factors that the draftsman would need to be very careful in respect of.
Thank you very much.
Paula, if I could just come in on that as well, just if you don't mind, in relation more to your first question, I think that, the recent polling on this issue in relation to a Bill of Rights, I think there was 83% of those polled thought that a Bill of Rights is important for Northern Ireland. And I think that it sets a tone for Northern Ireland and the type of society that that we are and that we want to be. And I think that it is important for people. I think it's important that, and I don't want to take away from those pieces of legislation that you're talking about, because I do think they're very important. But I do think that the Bill of Rights would be the place in which to have them tied together, and that they can then be supported by other pieces of legislation, but that they are there in one Bill of Rights that people can access and say, okay, this is what my rights are, or these are the rights that we have as individuals. So I think that it's again coming back to, what came out of the Good Friday Agreement, what we've been talking about for 22 years, and what, the position that we're in now in terms of, I think, the need to protect human rights and to protect them going forward as well.
Thank you.
Okay, Paula, we'll go to Mark next.
Thank you, Chair, and thank you for the presentation. I haven't any questions per se this afternoon, Chair. I've been listening. It's been extremely interesting, and anything that I had been going to ask has either A, been asked, or B, been answered without being asked. So thank you.
Thanks.
No problem. John?
Hello, Chair, and thank you to Peter and Maria for your presentation. I'm not even sure if I have a question. Maybe it's more of a commentary. I might get their question as I make my commentary, so bear with me. As a legislator, the first question I ask myself is legislation necessary to solve the problem or the opportunity in front of me? And if the answer is yes to that, then what I want in front of me, or then what I want to end up with, is a piece of legislation that is workable and enforceable. And this week in the Assembly, we've seen a well-intentioned amendment to a piece of legislation which may have had huge financial consequences for the executive, and there had to be a bit of negotiating and a bit of politicking done to resolve that issue. So I want to see legislation which is workable and enforceable, because the point I'm trying to get to is, quite understandably, elected representatives will be concerned that the courts take power away from them. And there is a democratic imperative that elected representatives are there to make the laws. But there is also a danger that elected representatives make unworkable and unenforceable laws. So it's not simply around the Bill of Rights. In that sense, there is concern that the Bill of Rights will take away power. But if we make the wrong laws in the Assembly, then they're going to end up in court anyhow. So I suppose the point, or the question I'm trying to get to, is this. And it's a point you made, Maria, and in fairness, Peter covered it as well. Rights have to be enforceable, and that's whether it's a Bill of Rights, whether it's Section 75, whether it's the Rural Needs Act, whether it's the Human Rights Act that we've talked about, or even in terms of educational rights. And we see a lot of, and you'll be aware of this, Maria, in your role, in terms of, well, in the Children's Law Centre, anyway, in terms of educational needs. So how do we ensure, well, the legislators have to ensure the legislation is proper, but how do we ensure that we do have an enforceable Bill of Rights, which is a useful piece of legislation and an enforceable piece of legislation.
Okay, well, when you were making those points, John, and you talked about Section 75 and the Rural Needs Act, the thing that occurred to me about those is that, generally speaking, the enforceability mechanism for them is not the maybe traditional hard-edged enforceability mechanism. It requires certain identified government bodies to have regard to the need to secure equality, the need to ensure reflection of rural needs, etc. And that's perfectly valid, and I think it reflects the reality that very often what lawmakers want to do is to set the tone, to project soft power, if you like. This is what we're looking to try to achieve. But they do so in a way that recognises that we live in an imperfect world, that there are financial constraints, and that at times there will be different ways of achieving things and more than one way to skin a cat. And so I think much of this will depend on the model that's eventually adopted and across the spectrum from aspirational rights to hard-edged rights, and where you find the Bill of Rights sitting on that spectrum whenever you get to it. And it might even be mixed. Maybe within it, some elements of it will be more hard-edged than others. And as I've said, the more hard-edged they are, the easier it is to enforce them, because you have right X that says an individual has a right to whatever it might be. And if they don't get that, then they go to court and the courts enforce it. So it's not, in that circumstance, it's not the situation, actually, I would say to you respectfully, whereby the elected representatives are having power taken away from them by the courts. In actual fact, what's happening is the courts are reflecting the reality that the elected representatives wanted to achieve, and they are enforcing it. So it was an opportunity for the judicial branch of the system of government to work hand in glove with the legislature and the executive to achieve that which is to be achieved. And I mean, as the Chief Justice made clear throughout his presentation, the judges don't make the law. The judges are not there to come up with law. They're not placed to do that. They don't have the democratic accountability to do that. They don't have what you all have as being tribunes of the people to make laws on behalf of the people. But what they do have is the independence and the power under our system of law, the rule of law, to make sure that that which has been brought into law is upheld and enforced. And that's vitally important, obviously, and our courts, I would say to you, have never shied away from doing that. And I think that a Bill of Rights coming in the future will be met with that kind of alacrity from the courts as well. So if you want it to be enforceable, then, I would say to make it so. But in making it so, you have to recognise the impacts that that has. So it will mean that, for example, if the Bill of Rights has some kind of fundamental role and sits above what might come afterwards from the Assembly, so the Assembly makes some law afterwards, one option might be mirroring the sort of Human Rights Act approach, where you say, well, if that law is incompatible with the rights under the Bill of Rights, then it'll have to be addressed in some shape or form. Either it's just a declaration of incompatibility, or if it's secondary legislation, that you give the courts the power to strike it down. And so that's the kind of enforceability that can be exercised. But if the laws, the rights that go under that law are vague, and I don't mean that in a pejorative way, I just mean in reality, if they are vague, they become more difficult to enforce because it brings into play more of the variables and factors that are recognised, by example, things like Section 75 of the Northern Ireland Act or the Rural Needs Act, that as opposed to, for example, some provision of a Social Security Act that provides a specific right to a particular benefit at a particular rate in particular circumstances.
So, John, I'll just come in there, if that's okay, from my perspective. And you're talking about, how do you make a Bill of Rights useful and enforceable? And I think that there's a couple of things, one of them being that, it's a matter of consulting with the public, I think, as well. And I know that you're doing that at the moment with the public consultation. I think that, people have to have a sense of involvement in it, if not, ownership, but involvement in it. And that this thing about human rights not being an abstract concept, it has to mean something. It has to have that granularity. What does that right mean to me? And so that has to be set out in whatever way you decide upon, which is not an easy task. I don't deny that. But I think then that there are different remedies then that you can have. And so I was interested by what Professor O'Regan had to say in terms of those localised tribunals. And oftentimes people have problems that they believe their rights have been breached. And if they get an airing of that problem in front of, it might not be a judge, but, a tribunal chair, for example, and that they might then be satisfied with that outcome. And that doesn't necessarily lead to, being in court every turnabout from the government's perspective. But there are those different remedies. And I think it's set out in the briefing by the Bar Library. There's these different sort of range of alternative dispute mechanisms as well can be built in. So when you have mediation, oftentimes these challenges don't get in front of a judge, because if people feel they have been wronged, and that in some way can be put right within the confines of the bill itself, that it doesn't necessarily result in being in court all the time. So the other point that I just wanted to make about that was, the fear of the power being taken away from the government and handed over the courts. Like, I do think it has to be maintained that this is not about and I don't mean to be dismissive, but about the whim of the government, because this government is not going to be the same as the next government, exactly the same, and it's going to change. But the rights should remain consistent and potentially evolve, but those rights should be set down in a piece of legislation, and that they should continue on into the future.
Yeah, and I've no difficulty with that. A Bill of Rights is in fact a constitution, but everybody knows the rules of the game as such. And going back to your earlier comments, Maria, around the identification of lawyers as activists and the criticism of lawyers by government, I fully agree with it. It's unacceptable. I as a minister, was legally challenged several times in court, and at times I didn't like the challenge. But I understand and fully appreciated and endorsed the right of the people to challenge me, because that is part of the democratic system. There has to be checks and balances to ensure that the laws I enforce or the laws I have introduced are properly administered. And the way you do that is through legal scrutiny. Sometimes it's not legal challenge, it's legal scrutiny, because I want to come on to the next point then. In our legal framework already, we have several mechanisms for resolving disputes rather than going to court. And I think I refer back to the education system again, that there's a tribunal there, which is not a court system, but there's a tribunal system at different levels to resolve disputes. So I fear sometimes that the concerns around the Bill of Rights ending up blocking up our courts takes on a life of its own, when it's not necessarily, and I don't believe it will be the case. Though, why in the first number of years of a Bill of Rights, if there's legal challenges, so be it. That sets the precedence for future ones, and perhaps will either improve or tidy up the laws in some way. So it's not really a question, it's more of a comment. Look, thank you very much for your presentation. You may want to respond to some of that ramble or not, I don't know, but...
I suppose the only thing I would just add, and it's to echo something Peter already has said, that courts, judges, lawyers, they don't create new rights. They look at the rights that have already been put in, and in terms of any challenge, it's not challenging the ability or the power that the government had, it's challenging the legal limits of that power.
Yeah. Thank you.
Thank you.
Nice.
Thank you very much, and thank you for your presentation and your answers. I was encouraged to hear John O'Dowd's very conservative conservative legislative philosophy. We should only pass laws if we absolutely need to, and I absolutely agree with that. He's not going to come back on me for calling him a conservative, but one of the things that I think is this actually, John touched on it when he referred to, you're creating a constitution, and you will know in the United States of America there are effectively two schools of judicial thought. There's originalists who believe that the American Constitution should be interpreted through the prism of what those who authored it expected it to deliver. And then you have textualists who assert that, so for example, they think things like the Second Amendment to the Constitution, which allows for gun ownership, they think that that's a dated concept that goes back to a time when America was a new country and faced the very real possibility of invasion by the United Kingdom. In that context, when authors, in this case it'll be politicians, when authors put down provisions, they often can't envisage where they end up. So, for example, I would very much doubt if the people who wrote Article 8 of the European Convention of Human Rights could have envisaged a circumstance where that article would be used to prevent the deportation of people from this country who came here and stood on street corners demanding the murder of Jews and Christians and other groups that they don't like. So if you could talk to that in terms of what was originally intended and then how these things can actually end up being interpreted.
Yeah. Well, the Human Rights Act 1998 incorporates many provisions of the European Convention of Human Rights into our domestic law. The European Convention was created in 1950, and I think it'd be fair to say that the world of 1950 is very different in many, if not every way, from the world that we inhabit now today. And the Convention and the jurisprudence that's developed around the Convention has developed maybe not a pace with society, but it certainly has striven to reflect developments in societal approach and in societal norms. And I think that you could probably expect that that would be the way in which a Bill of Rights is more likely than not going to develop over time in our jurisdiction. So I think, again, this may be something that a preamble might touch upon. It might specifically try to guide the courts as to how the document might live and breathe as years go by. And you're right, I think, Christopher, to say that in doing that, you would move into territory where you might be creating that document in the year, say, 2022. But it will resonate down through the generations and could still be open to interpretation 100 years later, maybe 200 years later, maybe beyond, without the legislature having interfered greatly with it. And maybe that's the way it has to be. We don't know what the world would be like in 50 years' time, the type of life that our children will have in that time. So should we set parameters now on what the rights that they should enjoy in that time to come should be? And I think there must be room for it to become a living document. I was struck by, when you were making those remarks, by some of the obituaries that I've read in the last few days for Lord Kerr. Maria quite rightly referred to Lord Kerr in her remarks a while ago. A colossus in the law in this jurisdiction and further afield, who sadly died last week. Very untimely, sudden death, in circumstances where he had very much more to offer still to the law in this jurisdiction. But during his time as a lawyer and as a judge, both in Northern Ireland and then on the UK Supreme Court, he was very much one of the drivers of developing the law as a living thing and not something that simply is, to use my phrase familiar, dusty documents on lawyers' shelves. And you look at some of the cases that he dealt with on the Supreme Court in particular, very often as a dissenting voice on the Supreme Court, and how he recognised the need for the law to reflect and touch upon the society that it serves. So I think the Bill of Rights would very much do that and should do that. But it does carry risks, clearly, because it means that you're legislating for something that you don't really know what the implications will be. And the current Chief Justice, I think, touched on this in his presentation to you as well, when he said that, towards the effect of it, it's not really possible to predict how those rights would then develop over the years to come.
I think constitution was the important word that the previous speaker used. If you move in the direction of written constitution, which the Bill of Rights in a very real sense is, that then opens up questions about the appointment of people who would interpret the constitution, doesn't it? Because if you have a written constitution that's interpreted in two different ways, you'll have two different schools developing. Then you're into questions about, in what wing or in what school do the judges who will be appointed to interpret it? And I foresee, if you're not too careful, you end up with similar situation that exists in the United States of America, where the interpretation of the Constitution is highly politicised, is right at the heart of the political process in terms of, people are elected president on the basis of promises to appoint judges of certain opinions and philosophies. And if we go down, I think one of the advantages of our system has been actually that we don't have a written constitution, that it does evolve organically over time. I'm just wondering, experience elsewhere in the world would indicate that written constitutions can end up highly politicising the judicial process.
Well, yes, we in the United Kingdom and Northern Ireland, in that sense, doesn't have a written constitution, for example, in the way that the Republic has, to use an example close by. And but what we do have currently is the European Convention on Human Rights, incorporated through the Human Rights Act, and it does give voice to the recognition and interpretation and enforcement of many fundamental rights that might otherwise in other parts of the world be founded in constitutional or fundamental law. And while I appreciate what you say in terms of the American experience, I have to say to you that it's not the experience that I would suspect most of my colleagues, and Maria hopefully will agree with me about this. It doesn't really reflect what we see as how our judges interpret the Human Rights Act and operate the Human Rights Act, that they still do so very much on legal principle and not on any kind of political aspect far from it. And in fact, you nearly say God forbid. I mean, they would be horrified, I think, at the prospect of that, as would, I think, all lawyers in this jurisdiction. So I appreciate the point you make and the concern that you give rise to, but I think that the experience here, thankfully, has been somewhat different and more legalistic in nature, and I think that you would expect that more likely to be the way into the future, and particularly if addressed specifically in some kind of preamble type way that gives life to what it is the legislature is expecting from the judiciary in terms of dealing with a bill of rights.
That's grand. Thank you.
All right, Christopher. Peter and Maria, we've dragged you both over the coals and taken up a lot of your time this afternoon. So thank you both very much for joining us and for your presentations and answering all our questions.
Thank you. Thank you, Chair. Thank you, everybody.
Thank you.
All right.
All the best. Bye.
Bye-bye now. Bye.
Okay, members, so we can move on. So we've skipped an agenda item because we took the presentations together. So the next is Chair's business. We don't have any this week. And we then have the draft minutes, if everyone is happy to agree. Minutes from last week. Okie dokie. We don't have any matters arising. Then there's 2 items of correspondence. You'll find the memo at page 28 of your packs. And it was just to note, firstly, the letter from Professor Bryce Dixon, who has followed up with a point of clarification following his presentation last week and an answer that he gave to John O'Dowd about the Assembly's legislative competence. And then we have a letter from the Office of the Attorney General that responding to an invite that we had given to her, suggesting that we invite her if necessary to assist us in any specific legal matters if we consider that helpful. So if everyone's happy to content to note those. And then agenda item 8 is forward work programme, which you'll find beginning at page 32 of the meeting pack, if members are happy to note. Do members have any other business? So the date, time and place of the next meeting is the next room, Thursday the 17th of December, 2 p.m. All right.
Thank you.
This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30.